I will proceed from the second petitioner's case, that is Thomas Kimotho Maingi. Thomas Kimotho Maingi, the second petitioner in the consolidated petitions, filed a petition dated 25th September 2024 before the High Court at Kerugoya. The national and contended that his constitutional rights had been violated by statements allegedly made by His Excellency Gachagua on 26th of June 2024 concerning the conduct of NIS during the Finance Bill 2024 protests. He averred that, having served in the NIS for over 20 years before 2022, he was publicly associated with the intelligence service within his community, and that the remarks by His Excellency Gachagua portrayed NIS officers as incompetent and responsible for the unrest and loss of life witnessed during the protest. The remarks exposed him to ridicule, hostility, threats, or distress, forcing him to leave his home in Kirinyaga County and seek refuge in Embu County out of fear for his safety. Mr. Maingi further contended that the Attorney General, AG, failed in his constitutional duty as the principal legal advisor to government by failing to advise His Excellency Gachagua appropriately regarding the provisions of sections 24, 25, and 26 of the National Security Intelligence Service Act relating to complaints against the NIS. The petitioner alleged violations of Articles 10, 27, 28, 29, and 47 of the Constitution, claiming that the impugned statements amounted to discrimination, infringement of human dignity, psychological torture, and unfair administrative conduct. Consequently, the petitioner sought the following reliefs: that there be a declaration that the constitutional rights of the applicant as provided for under Articles 10, 27, 28, 29, and 47 of the Constitution have been violated by the respondents. B, that the first respondent be ordered to issue an apology to the NIS members and staff for the utterances and or speech made on the 26th of June 2024. C, cost of the petition, and D, any other relief the court may deem. The second petitioner did not, however, file any written submissions. The third petitioner's case. Honorable Njeri Maina, the third petitioner in the consolidated petitions, filed the petition dated 2nd of October 2024. That was later amended on the 9th of October 2024 before the High Court at Kerugoya. She is the current woman representative in the National Assembly for Kirinyaga County. She stated that she brought the petition on her own behalf and on behalf of the residents of Kirinyaga County, and in public discretion as and in public interest, her petition also principally challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings commenced against His Excellency Gachagua. She contended that the public participation process undertaken by the National Assembly in relation to the impeachment motion was ineffective, inadequate, and constitutional owing to the short notice periods and inaccessible venues. She took issue with the insufficient dissemination of information, defective response templates, lack of proper facilitation of members of the public, and the alleged failure by Parliament to comply with court orders directing constituency-level public participation. She further asserted that the impeachment process violated Articles 10, 47, 48, 145, and 150 of the Constitution, and challenged the constitutionality of Standing Order number 64, 2 of the National Assembly Standing Orders on the basis that it imposed an unconstitutional 7-day timeline for disposal of impeachment proceedings, thereby undermining meaningful public participation. Honorable Maina also questioned the legality of the Senate's decision to conduct the impeachment proceedings through a special committee under Article 145, Sub-Article 3B of the Constitution, urging that investigation of impeachment charges could only lawfully be undertaken by a select committee of the Senate. In addition, she challenged the legality of the National Assembly as constituted, contending that it failed to comply with the constitutional 2/3 gender principle under Articles 27B, 102, 161 of the Constitution, and was therefore incapable of lawfully entertaining an impeachment motion. As such, Honorable Maina sought for the following reliefs. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th October 2024 regarding the special motion fell below the threshold of proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the modalities put in place by the first respondent in respect of the public participation forums held on 4th and 5th of October 2024, as ordered by this Honorable Court regarding the special motion, were in disregard of the Court's orders and fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. C, a declaration that the impeachment process, as again as the first interested party, undertaken by the first and the second respondents in their in view of modalities of public participation forums held on the 4th and 5th October 2024, failing well below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution, were unconstitutional and therefore void. D, a declaration that the appointment of a select committee by the Senate under Article 145(3)(b) of the Constitution is not discretionary in the impeachment of a president or deputy president in light of Article 259 of the Constitution. A declaration that any proceedings in regard to impeachment of the first interested party taken by the second and fourth petition respondents outside the select committee of Senate under Article 145, Sub-Article 3B of the Constitution are unconstitutional and void. F, a declaration that the first respondent is not legally constituted in light of the mandatory provisions of Article 27, 81B, 10261 of the Constitution on the 2/3 gender requirement. G, a declaration that the first respondent as currently constituted cannot entertain and deliberate the special motion for the removal of the first interested party by respondents. H, cost of the suit, and I, any other order or orders that this court may deem just. The third petitioner's submissions. Honorable Maina supplemented her positions by filing written submissions dated 9th of January 2026, and which she further orally highlighted in court. She identified the following issues for determination. 1, whether the public participation exercise conducted by the National Assembly on the 4th of October 2024 met the constitutional threshold under Article 118 of the Constitution. B, whether the yes-no template deployed by the National Assembly violated constitutional requirements for meaningful public participation. 3, whether the Senate violated Article 118 by not conducting public participation at the Senate stage. 4, whether the Senate violated Article 145(3)(b) by failing to appoint a special committee of 11 members. 5, whether Standing Order 64-2 prescribing a 12-day impeachment timeline is constitutional. 6, whether the impeachment violated Article 50 on fair hearing protections. And 7, whether the impeachment proceedings were conducted by impartial officers as required by Article 50, Sub-Article 1 of the Constitution. Honorable Maina submitted that on the 3rd of October 2024. Honorable Justice Mongo, a judge of the High Court sitting at Kerugoya, ordered inter alia that public participation be undertaken at the constituency levels so as to accord the public an opportunity to engage and offer their representations. That these orders were duly served and were never appealed, stayed, varied or reviewed, and as such, the respondents absolutely. Speaking to the obligation to obey court orders, Honorable Maina submitted that such obedience is foundational to the rule of law, as was held in Law Society of Kenya and 3 others versus Inspector General of Police, and 4 others reported in 2024 KEHC, KLR. She submitted that this obligation extended even to cases where the person affected by an order believes it to be irregular or void, as was held in Refrigeration and Kitchen Utensils Limited versus Gulabchand, Popatlal Shah, and others, the civil application number Nairobi 1339 of 1990. She further submitted that proper compliance required reasonable notice and not the same day or the next day notice. Physical accessibility at constituency level with open, identifiable venues in each of the 290 constituencies, facilitation of engagement, including civic sensitization, information, language diversity, disability access, and hearings as the primary mode, including oral and interactive engagement. Learned Counsel further submitted that the orders were not obeyed and only 200,000 participants countrywide who made up to 0.4% of the Kenyan population turned up for the exercise. Council decried the one-day notice published on a Saturday, whose contents were vague as they referred to constituency offices without addresses and times. She also pointed out that no and that none of her counterparts within the Kirinyaga County were aware of the exercise. She further submitted that even the citizens who visited the constituency venue found them lost official staff who submitted that the Assembly faced a binary choice of obeying the Constitution through the court order or preserve Standing Order 64-2, which provided for 7 days deadline. They chose the latter, which Honorable Maina describes as content dressed as obedience. That a legislative outcome obtained in defiance of a binding court order cannot stand in a constitutional democracy governed by the rule of law as discussed by Lord Denning in McFoy v. United States Company Limited, United Africa Company Limited, reported in 1961, 3 All England Reports 1169, where the learned judge held that, I quote, if an act is void, then it is in law anality. You cannot put something on it and expect it to stay there. It will collapse, end of quote. Honorable Maina also took issue with the yes and no template as constitutional fraud, as the National Assembly deployed a standardized template reducing 7 complex constitutional allegations into binary tick box questions. That citizens were asked whether they supported impeachment on each ground without being supplied with evidentiary material, explanatory memoranda, and His Excellency Gachagua's response. Says Cabinet Secretary for Health 2019, which we'll hear in after be referring to as the BAT case. She articulated attributes of meaningful participation to include clarity of the subject matter for the public to understand, structures, processes that are clear and simple, opportunity for balanced influence from public, commitment to the process such that views can influence outcomes, and inclusive and effective presentation. She also listed integrity, transparency of the process and capacity to engage on the part of public, including sensitization of the subject. Mrima admitted that the digital-only, English-only mechanism systematically excluded rural residents, the elderly, persons with disabilities, the non-English speakers, and the non-English speakers. She stated that there were no physical venues for explaining the template or receiving oral views, that were only in 10, that there were only 10 pictures of people attached as evidence of attendance for the 5th October exercise, and that they were contained conflated responses from 4th and 5th October without distinction, obscuring the impact of the court's orders. She identified that the template was not a procedural imperfection, but an endorsement mechanism designed to manufacture numerical support for a predetermined outcome and is therefore constitutionally void. It was her further submission that Article 118 imposes an independent obligation on each House of Parliament to facilitate public participation in its own business, that the Senate is not a subordinate appendage of the National Assembly, as was held in Speaker of Senate versus Attorney General, reported in 2013, where she stated that the Senate's role in impeachment is determinative under Article 145(7), as it performs a quasi-judicial function of the highest constitutional order. She held the position that the Senate could not constitutionally rely on the National Assembly's defective process, particularly where that process was conducted in defiance of court orders, that the Senate was aware of these defects as they were documented, litigated, and judicially acknowledged. Counsel submitted further that in Mwangaza versus Speaker of the Senate 2025, reported in 2025 Kinyalo reports, this court held that Senate must satisfy itself that public participation was adequate and satisfaction requires inquiry, assessment, and independent judgment, but the Senate undertook none. That the Senate conducted no public participation whatsoever, as no notices were issued, no invitations were extended, no hearings were conducted, and no submissions were received, and that this is not a case of inadequate participation, but a case of none at all. It was also her submission that Article 145, Subarticle 3B of the Constitution provides that the Senate may appoint a special committee comprising 11 members of its members to investigate the matter. On that, it submitted that the word may was a grant of power, not a license to bypass the Constitution, and that once the Senate had elected to proceed under Article 145, it must proceed within the architecture prescribed, which includes a special committee. Further stated that under Article 145, Subarticle 6, it provides that the Senate jurisdiction to vote is triggered only if a special committee reports that allegations have been substantiated, and absent a committee report, the gateway to plenary determination was not opened. She also stated that the constitutional function of the special committee was structured investigation, not political debate, receiving, interrogating, testing evidence, producing a reasoned report, and insulating investigation from the volatility of plenary politics. That Article 145, Subarticle 5 of the Constitution, guaranteed the Deputy President the right to appear and be represented before the special committee, and by bypassing the committee, the Senate extinguished an entire constitutional hearing stage guaranteed to the Deputy President, thus violating the non-derogable right to a fair hearing. Learned Counsel submitted that standing orders confirmed this distinction as Standing Order 79 on the Deputy President impeachment provided for a special committee, but no alternative. That Standing Order 80 of the Governor's impeachment procedure provides two alternatives, that is, a special committee or a plenary investigation. Then posited that where the drafters intended to permit plenary investigation, they could have said so, and that the omission of the Deputy President must be respected. Learned Counsel 3B of the County Government Act, which that the Senate may appoint in governor have held that this confers discretion and the Senate has lawfully proceeded in plenary. Those decisions underscore the opposite point. The law expressly provides alternative and discretion exists, but where the Constitution provides, the discretion does not extend to inventing another. She submitted that by proceeding to plenary determination without appointing a special committee, the Senate acted without jurisdiction, bypassed a constitutionally mandated investigative stage and extinguished a guaranteed hearing right. She also submitted that Senate had collapsed constitutionally distinct phases into a single political exercise, and the impeachment proceedings were therefore unconstitutional, null and void ab initio. It was a further submission. Standing Order 64-2 lay at the heart of the constitutional infirmity, as it imposed unreasonable timelines that rendered compliance with the Constitution impossible. Council invoked Article 2(4) of the Constitution, which provides that any law that is in conflict with the Constitution is void to the extent of the inconsistency. She placed reliance on Orange Democratic Movement Party versus Speaker of the National Assembly, reported in 2024, where this court affirmed that standing orders cannot override the Constitution nor substitute the constitutional requirements of public participation as expounded by the courts. In that light, Parliament's invocation of good faith was faulted, it being argued that Standing Order 64-2 structurally precluded constitutional compliance. She submitted that where standing order made adherence to constitutional obligations impossible, such a standing order is itself unconstitutional. It was further submitted that Standing Order 64-2 embodied a deliberate parliamentary choice to prioritize political expediency over constitutional safeguards. By prescribing rigid timelines, it ensured that once an impeachment motion gained initial traction, the process would be driven to conclusion before public sentiment could evolve, before courts could intervene meaningfully, or before the affected office holder could mount an effective defense. Counsel argued that this was a mere vote of no confidence, but a quasi-judicial constitutional process carrying grave consequences. On that basis, it was to declare standing orders constitutional to the extent that its lines in compatibility impeachment with legality from inception. On the question of whether His Excellency Gachagua was accorded a fair hearing, Honorable Maina submitted that he was hospitalized with chest pains on the eve of the Senate proceedings. Despite medical evidence of incapacity, the Senate proceeded with the hearing and voted, thereby violating the most basic tenet of the fair hearing rule, audi alteram partem, meaning no person shall be condemned unheard. Counsel further argued that the 12 days between service of the motion and the National Assembly vote were constitutionally inadequate, given that Article 50, Subarticle 2B guaranteed the right to have sufficient time and facilities to prepare defense. His Excellency Gachagua, it was emphasized, faced 11 complex constitutional allegations, including gross violation of the Constitution, abuse of office, and corruption, for which 12 days was structurally insufficient. As the Supreme Court affirmed in Sonko case, which we referred above, impeachment proceedings attract the protections of Article 50, and where a fair hearing is denied, the process collapses. On the issue of bias and predetermination, Learned Counsel submitted that both Speakers of Parliament, as presiding officers over the impeachment motion, were constitutionally required to maintain impartiality, but acted contrary. It was argued that they assumed the role of initiators and proponents of the impeachment, thereby transforming into advocates for the motion rather than neutral. Moses was said to statements endorsing the impeachment before presiding over the proceedings. Counsel emphasized that the test for bias is objective, where a reasonable, fair-minded observer would conclude that there exists a real possibility of bias, and submitted that the Speaker's public statements and advocacy for impeachment satisfied this threshold. Where the presiding officer is biased, she argued, the proceedings are fundamentally unfair, and the failure of the speakers to rescue themselves irredeemably tainted the process. For the above reasons, Honorable Maina urged the court to grant the relief sought in her petition. Next is the 4th to 8th petitioners' cases. The 4th to 8th petitioners in the consolidated petitions, that is Honorable David Munyi Madenge, Peter Gechobi Kamoto, Grace Modoni Mwangi, Clement Muchiri Muriuki, and Edwin Munene Kariuki, jointly filed a petition dated 18th of October 2024 before the High Court of Kenya at Kerugoya. They describe themselves as residents and leaders drawn from various constituencies within Kirinyaga County, and stated that they instituted the petition both in their personal capacities on behalf of their residents of their respective constituencies and in the wider public interest. The petitioners herein challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua, together with the subsequent nomination and approval process relating to Honorable Kindiki, relating to His Excellency Kindiki as Deputy President nominee. They contended that the public participation process conducted by the National Assembly on the 4th and 5th was illusory, inaccessible, and unconstitutional. In particular, they pointed to the issuance of short and ineffective notices, lack of sensitization, inaccessible venues, absence of parliamentary officials at designated constituency sites, closure of the Kirinyaga Central CDF Hall, and the overall failure by both the National Assembly and the Senate to facilitate meaningful participation as required under Articles 10 and 1. The petitioners further asserted that Senate unlawfully conducted impeachment proceedings in plenary instead of through a special committee and Article 145(3)(b) of the Constitution, and that the rash timelines imposed under Standing Order 64(2) of the National Assembly standing orders were unconstitutional, as they curtailed effective public participation and the hearing and the fair hearing rights. They also alleged that the Senate violated His Excellency Gachagua's constitutional allegations. They also alleged that the Senate violated His Excellency Gachagua's non-derogable rights under Article 25(c) and 50 of the Constitution by refusing to adjourn proceedings on the 17th of October 2024, despite his hospitalization and medical emergency, thereby denying him an adequate opportunity to be heard. In addition, the petitioners challenged the legality of the nomination and approval process of His Excellency Kindiki as Deputy President nominee, contending that the process contravenes sections 3 and 6 of the Public Appointments Parliamentary Approval Act, Chapter 7 of the Laws of Kenya, for want of adequate notice and public participation. The petitioners then sought the following prayers. A declaration that the appointment of Professor Kithure Kindiki, the second interested party herein, as Deputy President of the Republic of Kenya is invalid, null and void. B, a declaration that the National Assembly as a distinct organ is required to undertake its own distinct, proper, effective and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to the impeachment of a president or a deputy president. C, a declaration that the Senate as a distinct organ was required to undertake on its own distinct, proper, effective and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to a resolution from the National Assembly to impeach a president or a deputy president. D, a declaration that the public participation as scheduled by the first and the second respondent on 4th of October regarding the special motion was not a proper and effective and meaningful public participation as envisaged in Articles 10 and 18 of the Constitution. E, a declaration that the extended public participation scheduled by the first and second respondents on 5th October 2024 was in disregard of the court orders issued by the High Court sitting at Kerugoya in constitutional petition number E014 of 2024, Honorable Jane Jerry Maina versus the National Assembly and 4 others, and was not a proper, effective and meaningful public participation as envisaged under Article 10 of the Constitution. F, a declaration that the impeachment process as against the first interested party was undertaken by the first and second respondents in view of the impugned, improper, ineffective and meaningful public participation held on the 4th and 5th October was unconstitutional and therefore void. G, a declaration that the failure by the third and the fourth respondents to undertake any public participation at all in regard to the impeachment proceedings in the Senate as against the first interested party renders the whole Senate impeachment process unlawful and void. H, an order of certiorari to bring up into this honorable court and quash the decision and or the resolution by the first and the third respondents made on the 8th of October 2024 and 17th of October 2024, respectively, resolving to remove the first interested party as Deputy President of Kenya by impeachment. I, that there exists vacancy in the office of the Deputy President, allowing the fifth respondent to nominate anyone to fill such vacancy, and that any such nomination is unlawful and void. J, any other order or orders that this court shall deem just and expedient in the circumstances. K, cost of the suit. Next is the 4th to 8th petitioners' submissions. In their submissions led by counsel, Mr. Evans Ogada, together with Mr. George Sakimpa, the 4th to 8th petitioners identified the following issues for court's determination. A, whether the impeachment process complied with Articles 10, 118, 145, and 150 of the Constitution, whether the public participation conducted by the National Assembly and the Senate met the constitutional threshold of being meaningful, adequate, effective, and lawful. C, whether a standing order 64-2 of the National Assembly is unconstitutional for imposing rigid timelines that undermine constitutional safeguards. And D, whether Article 145 and applicable standing orders require that investigation into impeachment charges be conducted exclusively by a special committee of the Senate, not by the Senate sitting in plenary. They submitted that Article 10 binds all state organs, including Parliament, to the national values such as democracy, public participation, the rule of law, accountability, and good governance. That the impeachment process was conducted with severe haste and limited deliberation, undermining transparency, accountability, and public participation. They relied on the Supreme Court decision in Speak of the Senate versus AG and another reported in 2013, where it was held that Parliament was not exempt from constitutional discipline. They submitted further that Article 118 required Parliament to conduct business openly and facilitate public participation, and that this was not a formality, but a substantive constitutional obligation. They contended that the National Assembly gave the public less than 48 hours to consider complex, voluminous impeachment charges, which is a manifestly inadequate time frame, that no explanatory notes or responses from the Deputy President were inaccessible. They further asserted that the Senate conducted no independent public participation at all, as it is a deficient exercise, which cannot cure the constitutional breach, and they relied on authorities' report. National Assembly and another versus Okoit and 55 others. Civil appeal number E003/2023, consolidated with others. This is the decision of the Court of Appeal. They also relied on the decision of Doctors for Life and the report and the decision in Legal Advice Center, and two others versus County Government of Mombasa. On the unconstitutionality of the National Assembly Standing Order 64-2, Learned Counsel argued that the provision imposes rigid and unreasonable timeline that make meaningful public participation impossible, and that while Article 124 empowered Parliament to make standing orders, such orders are subordinate to the Constitution and cannot defeat constitutional rights, and Article 24 voids any law inconsistent with the Constitution. The petitioners urge the Court to declare Standing Order number 64-2 unconstitutional. As the matter in which the Senate proceedings were to be undertaken, Council submitted that Article 145(3) provided that the Senate must appoint a special committee to investigate impeachment charges, and that the use of the conjunctive "and" between sub-articles A and B makes the special committee process constitutionally inseparable from the investigative phase. That Articles 145, Sub-Article 4, Sub-Article 5, and Sub-Article 6 refer exclusively to the special committee, and that there is no mention of plenary investigation or under expresso inius est exclusio ulteriors that excluded all other modes of investigation. The petitioners submitted further that the special committee ensured separation of investigations and adjudicative functions, preventing bias and predetermination, and the Senate's decision to bypass the special committee and proceed in plenary fuse investigation, hearing, and the judgment into a single political process, violating the hierarchical and sequential structure of Article 145. Learned Counsel placed reliance on Martin Nyaga, Wambora, and three others as the Speaker of the Senate. This is the Court of Appeal decision, where the Court of Appeal held that the removal of a governor, which mirrors Article 145, is hierarchical and sequential in nature. Counsel argued that the Deputy President was denied a constitutionally prescribed procedural safeguard available to state officers facing removal, thereby violating Article 27 on equality and non-discrimination. They further submitted that Article 50, Sub-Article 1 guarantees the right to a fair hearing, which is expressly protected as non-derogable under Article 25C. Proceeding with impeachment proceedings while the Deputy President was hospitalized and rejecting a reasonable request for adjournment amounted to a gross violation of natural justice. Counsel emphasized that fairness was the unassailable foundation of any removal process. In support, they cited Gachagua versus Speaker, National Assembly, and three others, High Court decision, where the High Court reaffirmed that the right to a fair hearing as non-derogable and that any violation renders the process null and void. Counsel concluded by submitting that the Constitution does not permit Parliament to sacrifice legality at the altar of expediency, and urge this court to reaffirm constitutional supremacy and protect the sovereignty of the people of Kenya. The petitioners prayed for declarations and that the impeachment process violated Article 10, 118, 145, and 150. A declaration that Standing Order 64-2 is unconstitutional, a declaration that the Senate unlawfully bypassed the special committee, and orders quashing the impeachment resolution. We'll now proceed to the 9th petitioner's case. Sheria Mtaani na Shedrack Omboy, a public benefit organization, filed the petition dated 18th of October 2024, together with a supporting affidavit sworn by Dorcas Moine, an advocate of the High Court of Kenya, and the director thereof. The petitioner stated that it is established to assist members of the public in assessing justice, protecting rights, and promoting the rule of law, constitutionalism, accountability, and good governance. The petition challenged the constitutional and the legal validity of the impeachment proceedings, leading to the removal of His Excellency Gachagua from office as Deputy President, and further questioned the legality of the intended nomination and approval of His Excellency Kindiki as his replacement. It contended that the Senate proceedings conducted on the 17th of October 2024 violated His Excellency Gachagua's constitutional rights under Article 25C, 47, 50, and 45, sub-Article 5 of the Constitution. That the Senate unreasonably declined to adjourn the impeachment proceedings, despite being informed that His Excellency Gachagua had fallen ill and had been admitted at current home, thereby denying him an opportunity to personally defend himself against the impeachment charges. It was further alleged that the Senate acted in breach of the constitutional requirements of fair hearing, procedural fairness, and natural justice by proceeding with the impeachment in the absence of His Excellency Gachagua, while allowing the proceedings to continue on the basis of strict constitutional timelines. It asserted that although the Constitution contains a expeditious impeachment process, the constitutional timelines could not override His Excellency Gachagua's non-derogable right to a fair hearing and adequate opportunity to defend himself. Sheria Mtaani na Shedrack Omboy further complained that the proceedings before Senate were rushed, insensitive, and conducted in a manner that prioritized speed over substantive justice and constitutional safeguards. Additionally, the 9th petitioner challenged the legality of the subsequent process initiated by His Excellency the President to nominate His Excellency Kindiki as Deputy President under Article 149 of the Constitution. It was contended that the nomination violated Articles 82, 88, and 137 of the Constitution because IIBC was allegedly not properly constituted and therefore incapable of lawful verifying the constitutional qualifications of any nominee to the office of the Deputy President. Sheria Mtaani na Shedrack Omboy also argued that His Excellency Kindiki's nomination contravened Article 137 of the Constitution on the basis that he remained a serving Cabinet Secretary for Interior and National Administration at the time of his nomination. For these reasons, the organization sought the following prayers. A declaration be and is hereby issued that the rights and fundamental freedoms of the interested party herein, to which his rights and fundamental freedoms under Articles 25, 50, 27, 47, 145 were grossly violated by the third respondent on the 17th of October 2024 for declining to grant him an adjournment on the Senate sitting deliberating on his removal from office by way of impeachment. B, a declaration does hereby issue that the decision by the third respondent to have the interested party removed from office by way of impeachment, to the extent that it was done in gross violation of Articles 25, C, 50, 27, 47, and 145.5 of the Constitution was unconstitutional to the extent of its unconstitutionality, and null and void ab initio. C, a declaration that any subsequent replacement of the interested party, if at all, to the office of the Deputy President of the Republic of Kenya was unconstitutional and therefore null and void ab initio. D, a judicial review order of certiorari does hereby issue to bring to its court, to this court, the decision of the third respondent as communicated via Gazette notice dated 17th of October 2024, communicating the removal from office of the Deputy President from the office by way of impeachment. E, a judicial review order of certiorari does hereby issue to bring of the Republic of Kenya nominating Prof. Kithure His Excellency Kindiki as Deputy President of the Republic of Kenya for the purpose of quashing and the said appointment, and that the said appointment failed the qualification for the Deputy President as provided for under Article 137(2)(b) and 3 of the Constitution. F, alternatively, this court be pleased to make a declaration that the appointment of the Deputy President by the President to fill in the vacancy arising from the removal of the interested party from office pursuant to Article 149 of the Constitution must be read together with Article 82 and 88 of the met that the approval of Professor Kithure Kindiki or any other person as Deputy President of the Republic of Kenya is subject to Article 82 and 88 and 137 of the Constitution. Costs of the petition be provided, interest on one above at court rest, repayment in full, and this court be pleased to make any further and other relief as it may deem fit in the circumstances. In respect of the 9th respondent submissions, led by Counsel Shadrach Omori, the 9th respondent identified 3 principal issues for court's determination. A, whether the nomination of a Deputy President can be legally finalized or approved in the absence of a fully constituted commissioners of the IBC under Articles 82 and 88 of the Constitution. B, whether the Senate's refusal to grant His Excellency Gachagua an adjournment due to documented illness during the impeachment proceedings constituted a breach of the rights to a fair hearing and natural justice under Articles 25C, 47 and 50 of the Constitution. And C, whether the harm for violating eligibility criteria under Article 148 as read with Article 137. A learned counsel submitted that His Excellency Gachagua fell suddenly ill on the afternoon of the 17th of October 2024 when he was sent himself before the Senate, and that the Senate rushed the proceedings and unreasonably declined to adjourn to allow him to recuperate. That the Senate proceeded with ex parte proceedings, leading to his removal from office in his absence, which violated Articles 25C, 51, 47, and 145(5). The organization relied on the Supreme Court decision in Kithure and 4 others, versus Waititu and 4 others, reported in 2014, which affirmed that fair hearing incorporates the auli alteram valtem principle, and also referred to the Court of Appeal in Judicial Service Commission versus Mutava and another reported in 2015, KELA, which held that rules of natural justice apply to all bodies exercising judicial, quasi-judicial, or administrative duties. It submitted that Senate has no prescribed time limitation for completing different proceedings, and the rushing was unjustified. It was the organization's submissions that Article 148(1) requires that a person nominated as Deputy President must satisfy the requirements of Article 137 and 137(1)(b), or 137, and that Article 137(1)(b) provides that a person is not eligible for nomination as President and by extension Deputy President if they hold any other state office, and that Article 260 defines state officer to include a Cabinet Secretary. It submitted that at the time of the nomination and parliamentary approval on 18th of October 2024, His Excellency Kindiki was serving as the Cabinet Secretary for Interior, and therefore he did not satisfy the constitutional eligibility criteria, rendering his nomination null and void ab initio. It was the organization's further submission that at the material time in October 2024, the IBC was not fully constituted and it lacked the requisite number of commissioners, as the previous commissioners had resigned or retired. Articles 82 and 88 establishes a constitutional architecture requiring a lawful and fully constituted IBC to oversee electoral and nomination processes, and that the Supreme Court in IBC versus AG Advisory Opinion number 4 of 2024, reported 2025, held that an exercise of constitutional authority vested in the Commission as a collegial entity. It submitted that the exercise of constitutional functions reserved for the Commission under Article 88, Sub-Article 4, cannot be lawfully discharged in the absence of a properly constituted Commission with the requisite quorum. It was further submitted that in the absence of commissioners, IBC was constitutionally incapable from undertaking its mandated electoral processes, and that the approval of a deputy president nominee, the second highest constitutional office, is no less a substantive constitutional responsibility than delimitation of boundaries. The same principle applies with equal force. The organization urged this court to apply Article 10 on the national values and principle of governance that brings all state organs, Article 20, Sub-Article 3b in the dubia pro libertate doctrine, that where in doubt, the court ought to adopt the interpretation that most favors endorsement, enforcement of a right created in Jacqueline Okuta and another versus AG, High Court reported in 2017, and that it further submitted that the unconstitutional exercise of a legislative mandate cannot be shielded from judicial scrutiny, as was held in Commission for Implementation of Constitution versus National Assembly of Kenya and two others, 2013, KLR reported. In the end, the petitioner prayed that the petition be accordingly allowed